Good morning, everyone, and welcome to today's webcast, 2016 Legal Trends for Nonprofits. I'm your moderator today, Max Smith. I'm the Digital Marketing Manager with 501c Services, and I'd like to welcome everybody to today's webcast. It's our final one of 2016. I have a couple of housekeeping items for everybody, but before we get there, I'd like to introduce today's sponsor, 501c Agencies Trust. 501c Agencies Trust is a nonprofit unemployment risk management organization established in 1982 by a dozen nonprofits. And they provide educational claims management and protection services for an unemployment insurance program for 501c nonprofits. Housekeeping for today. If you have any questions for our presenters, please enter them into the questions box, which is on the left-hand side of your screen. We will moderate those as best possible and hopefully get to everybody's question and get everybody's answers today. This presentation is also going to be available on demand immediately following the session, so you can go back and watch it again, or you could forward it to other staff members or colleagues who you feel might benefit from today's information. There is 1 hour of general HRCI credit available for today's webcast. If you have registered for this webcast, you will get information about how to obtain that hour's worth of credit following the presentation by email. If you have any questions or concerns, you can please feel free to email me. And we do this system once a month on the last Monday of every month. So we're doing a little bit early this month because of the holidays. But the last Monday of every month at 12 noon, we cover topics such as these for nonprofits. So we'll hope you come back very often. And without further ado, let me go ahead and introduce today's speakers, Jerry and Ben. Jerry Pinero is a lawyer with Howe & Hutton. They have offices in Chicago and Washington, D.C., and he's been handling employment law for about 30 years with a large clientele of nonprofits. Ben Takis is the founder of Tax-Exempt Solutions in Washington, D.C., and he has also been working with for a number of years with nonprofits, helping them through their hassles and issues. So, Ben, I believe you're up first. If you'd like to go ahead and take it away.
Sure. Thanks, Mac. As Mac said, I work with nonprofit organizations on a wide range of issues, work a lot on nonprofit law, tax law, corporate transactions, things like that. And for me and my practice and my clients, the overall theme going into 2016 is transparency. So for the past few years, nonprofit oversight and disclosure has been a bit less aggressive than it has been in years past for a variety of reasons, but we may be starting to see a trend in the other direction. So the most interesting development over the past year has been litigation involving state attorney generals in a few different states to get access to the unredacted donor lists of nonprofits. First, some background about this issue. As you may know, nonprofits that are tax-exempt have to file some version of the Form 990, either the 990N, 990EZ, or the full 990, depending on the size of the organization. And if you're filing 990EZ or the regular 990, this includes Schedule B, which lists the name, address, and contribution amount of your major donors, generally those donors who've contributed more than $5,000 in the year. Now, the IRS is required by law to keep the donor identities confidential, and 990s that get released to the public have to have this donor information redacted. So that has been reassuring, and this donor anonymity has been a major factor in the trend to conduct more political activity through nonprofits, mainly through what we call 501c4 and 501c6 organizations. But federal law is not the only law that governs nonprofits. There's also state charitable solicitation laws. And 3 different states have started insisting that organizations that solicit contributions in the state provide the unredacted version of the Schedule B donor list as part of their registration requirements. Typically, registration requires some financial information, 990s, proof of tax-exempt status, things like that. And 3 states, California, New York, and Florida, have started requiring the unredacted donor lists. And a lot of people are worried about this kind of information getting into the hands of state governments. The states don't necessarily have the same resources and legal restrictions to keep this information private. So there's been some controversy about this, and in fact, First Amendment challenges in the courts. In California this year, there was a case called Center for Competitive Politics versus Harris, and it went up to the Ninth Circuit and was decided in May of 2015. And Ninth Circuit held in favor of California, upholding this requirement to provide the unredacted donor lists. There was similar litigation in the district court in New York, and it reached the same result. And just about a month ago, the U.S. Supreme Court declined to review the case. So the Ninth Circuit decision stands, and the New York case may get appealed. I believe it is under appeal, but as of now, this is the law. These attempts by the state officials to get the donor lists does stand as of now. So this is important to keep in mind, and you don't have to be a California, New York, or a Florida nonprofit to come under these rules. You simply have to be soliciting contributions in the state. So this presents something that a lot of nonprofits need to keep in mind because these are major areas for fundraising. And in some circumstances, if you're not even actively, aggressively soliciting contributions, but if a bulk of your contributions do come from residents of these states, this is something you're going to have to worry about. One other further twist on this issue, less than a week ago, the director of exempt organizations at the IRS mentioned at a conference that the IRS is thinking about whether to stop requiring the Schedule B at all. So this kind of puts this issue in a new light. I wouldn't count on the IRS doing away with the Schedule B requirement, but this is something to look for in 2016, and it's not clear if the IRS does away with the Schedule B, would the states persist in this requirement? Would they require organizations to submit the donor list on their own form if there was not a Schedule B? So the issue is far from settled. It's an issue to watch. My prediction personally, I don't think a ton of states are going to start imposing this requirement, but certainly the ones that are more active, California, New York, Florida, maybe a few others, I think they're going to be pretty persistent. So this is definitely something to keep in mind and keep an eye on going into 2016. Following the theme of transparency, there was another interesting development this year related to the 990. Towards the beginning of the year, there was some litigation regarding a Freedom of Information Act request for Form 990 from the IRS. The case involved the way in which the IRS responds to these requests and in what format do they provide the 990. So in the past, the IRS has always provided either a hard copy or an image scan of the Form 990. In other words, it's not a document you can search through. It's just a scan of the page. And it's kind of hard to do a lot with that kind of document. You could do it one by one, but you can't do a large-scale analysis, can't set up any kind of computer search. So one person who made this request took the IRS to court in California and asked that the IRS be forced to provide the documents in a form that machine could read and search through. It's what I will call a digitized form. And the IRS lost this case. They thought about appealing it, and in the end, around the summer of 2015, they dropped their appeal, and they decided to implement technology that would produce these digitized, machine-readable 990s on a mass scale starting in 2016. Now, they'll still have to redact the donor lists, but this could be significant. It's kind of challenging to work with the 990s, like I said, because you have to go through it manually. But once this technology gets up and running, it's going to become very cheap and easy to have programs that go through this tons of data and pinpoint exactly the data points you want to see. So public interest organizations, state governments, it's going to be much easier for them to get a bunch of 990s, do studies, and look for issues that they want to investigate further. So I'd say now is the time to kind of get your house in order. The 990s could be subject to a lot more scrutiny in 2016. With this change in technology, another issue going to need to keep in mind, many people are predicting that the IRS is going to shift a lot more attention to audits in 2016. A lot of this will deal with the rules governing tax-exempt organizations, what it means to stay a 501c3 or a 501c6, and they always look out for also employment issues that have a tax implication. Jerry might speak to some of that, but issues like independent contractor versus employee. But the IRS has said that they're going to be doing more audits in 2016. And particularly related to the technology, they're going to be using a more data-driven approach. So in the past few years, they focused mainly on specific types of organizations, colleges, universities, local chapters, lobbying and political organizations. But they're moving away from that approach, and now they're going to be looking more for patterns, inconsistencies, particular issues. And a lot of what will be driving this is what you put down on your 990. So the big question always when it comes to audits from the IRS, will they be actually able to follow through on this promise? That's not exactly clear, but this is part of a larger IRS plan that they announced going back to 2014. The IRS decided to shift a bunch of resources away from the application process, so the Form 1023, 1024, which you have to apply to get tax-exempt status. And instead, the IRS is going to look more at the back end. So once you are an organization that is up and running and tax-exempt, making sure that you continue to comply with those rules. You may have heard that the IRS put in place a new form of application called the Form 1023-EZ. And if you're a new 501c3 organization, used to be you had to submit a very long application supporting documents, total package anywhere from 50 to 150 pages. The 1023-EZ cuts out 95% of that process. It's kind of a self-certification where you just check some boxes and promise to comply with the rules. So the flip side of that frees the IRS up to, they're not looking at those applications nearly as carefully, and they can put all that extra energy and resources into audits. So I'd say more tension on the audit side is pretty likely going into 2016. A couple other issues that happened in 2015 that we'll want to keep an eye out. There was some new guidance this year on the topic of private foundation investments that do not qualify as what we call program-related investments. This is found in a notice that the IRS put out called Notice 2015-62. There's nothing shocking here. It's more just clarifying guidance that says a private foundation can accept a lower rate of return from an investment if the investment furthers the foundation's charitable purpose. So nothing groundbreaking here, but kind of a sign of the times of what foundations are thinking about, and a bit of an indication that a lot more philanthropy is being done through business endeavors and not just through traditional grants. Last week we had some news from Mark Zuckerberg, the Facebook founder, that he's going to be putting about $45 billion into charitable endeavors, and he's doing that through an LLC, not a foundation. And the purpose of that is so that he could be free to get involved in business ventures and investments that have a charitable purpose but are not necessarily tax exempt. So you can see the field is kind of wide open to all types of ventures that further a charitable mission, not just the traditional types of grants. So it's another trend to keep an eye on in 2016. And the last thing I'll talk about, the IRS is continuing to work on regulations regarding political activity, particularly for 501c4, social welfare, lobbying groups, 501c5, unions, and 501c6 trade organizations. The IRS has put this pretty near the top of their priority guidance plan, and they've said they're close, and they expect proposed regulations to come out in 2016. I'll note that there's nothing that's going to be final in 2016, and the IRS has no intention of putting out guidance that is going to apply for the upcoming election, but this is certain to be an issue that's going to be hotly debated throughout the year. And if you all work with 501c3 organizations, I'd keep an eye on this as well, because it's likely that whatever guidance the IRS puts out is going to be relevant for defining political activity with respect to C3s as well. So C3s cannot engage in political activity at all, so they need to be very aware of when their activities cross the line from permitted lobbying and advocacy activities into supporting or opposing a candidate for public office. So this is one of the hot issues. It's been dormant for a little while. The IRS put out proposed regulations in 2014 that were criticized and they were withdrawn, but they're going to be taking another shot at it, and that's likely to start happening in 2016. So that's my update on nonprofit and tax law, and I can pass it to Jerry now.
Okay, thank you, Ben. Good afternoon, everyone, and thank you for joining us. The two topics that I want to address this afternoon briefly have to do with the proposed regulations from the Department of Labor to change the regulations on who is an exempt employee and therefore doesn't have to be paid overtime, etc. And also the second topic I want to discuss is the misclassification of employees, as the whole issue of employee versus independent contractor. So if we can start first with the proposed regulations on exemption. The Department of Labor issued a notice of proposed rulemaking on July 6th of this year, 2015. Comments closed about 2 months ago on September 4, 2015. So now they've got to be evaluated, sifted, and then the Department of Labor will come out with with the proposed rule. There are three. If these go through, this would be a major change in the compensation, first of all, in who is classified as an exempt employee, and then secondly, in terms of the salary test that you would have to meet in order to get the exempt classification. There are basically three proposals in this proposed rulemaking. Number one is that the salary level tests would be updated to reflect current economics. I'll get to that in a moment. Number two, rather than having to change the salary level tests every couple of years or through a new rulemaking or something, the salary basis would be automatically updated, either in terms of a fixed percentage of wages, the consumer price index, but it would be automatically updated on an annual basis, so you wouldn't need to have a rulemaking. And then thirdly, the Department of Labor would revise the so-called duties test. Now, basically what that means is this. In order to be an exempt employee, I'm oversimplifying here just a little bit, but in order to be classified as exempt, you have to meet two tests. One, a salary test. You have to be making a minimum amount of money per week, and you have to be guaranteed that amount, regardless of the hours you work. And then number two, you have to have duties of a certain nature, basically management or duties that involve a line of business of the organization, that involve the exercise of independent judgment and discretion, minimal supervision. So that's what the duties test is. Right now, if an individual is paid as little as $455 a week, which comes out to less than $24,000 a year, and that individual meets the duties test, he or she can be qualified as an exempt employee, which means that regardless of how many hours that employee works in a week, he or she still gets the same salary, the same $455 a week, regardless of hours worked. Under this proposed rulemaking, that salary level would double. It would go up to $921 a week, which would work out to a salary of approximately $48,000 a year. So that's obviously a big jump in the salary level test. Secondly, there's also an exemption for what are called what are defined as as quote unquote highly compensated employees. Basically, these are people who make at least $100,000 a year in salary. That test would be increased. The new salary basis, the new salary minimum for quote highly compensated employees would jump to $122,000, a little over $122,000. So approximately a 20% jump. Now, according to the Department of Labor, these proposals could affect as many as 21 million workers, in fact, close to 21.4 million, who are classified today as quote-unquote exempt employees, meaning they're not entitled to overtime compensation. They would be reclassified as non-exempt employees, which means if they work more than 40 hours a week, they'd be entitled to be paid overtime. In the first year that these regulations go through, according to the Department of Labor, something on the order of 4.6 million workers who are currently classified as exempt would be classified as non-exempt. And approximately 36,000 highly compensated workers would become non-exempt. And the cost to the employer to implement these rule changes would be several $100 million, $240 to $255 million a year, just to implement these changes. Now, of course, it's anyone's guess when the Department of Labor is going to publish a final rule based on all the comments it gets. And also, bear in mind, next year is an election year. So depending on whether the new administration is Democrat or Republican, depending on what the makeup of the new Congress is, et cetera, it's entirely possible that even if the Department of Labor does come out with final regulations sometime in 2016, in 2017, a new administration might rescind those regulations or go back to the old way of doing things. But if these regulations do become final and go into effect, then, as I say, they will profoundly affect the classification of exempt versus non-exempt employees. One benefit, and again, we'll talk about this in a minute. One benefit to these proposed rules, if they are finalized and go into effect, is to simplify the so-called duties test for making that determination. Right now, it is extremely difficult. Excuse me. It is extremely difficult for employers and for attorneys alike who may be giving them advice to come up with a correct classification of whether an employee is exempt, quote-unquote exempt or non-exempt for purposes of the Fair Labor Standards Act. You have to consult advisory opinions, you have to consult case laws, you have to look very carefully at what the individual's job actually is, how much time he or she spends on specific tasks. It can be a very complicated process, and quite honestly, there's no guarantee that the employer or even the attorney is going to have the correct classification. If it's challenged, there's no guarantee that the Department of Labor or the court is not going to take a contrary view. Some organizations seem to classify everybody as quote-unquote an exempt employee. That clearly is not the case. There are bound to be several positions of sort of a clerical or administrative nature that are not going to be exempt, and therefore, in that sense, the employee may be misqualified. But in many cases, the classification can become very difficult. So anything that the Department of Labor can do to simplify those tests of what type of work you have to perform in addition to the salary in order to be classified as exempt is, in my opinion at least, is going to be beneficial and helpful. So we just have to see. Oh, and of course another point too is this: if you have a situation in which employees are not putting in any or a lot of overtime in their jobs, then of course to that extent that you're not incurring any overtime hours, these regulations are going to be moot in terms of exempt or non-exempt. Many organizations have rules or policies that say you have to have authorization in order to work overtime. It has to be approved. Bear in mind, if a non-exempt employee works more than 40 hours, he or she has to be paid for those hours over 40, whether they're approved or not. But you may be able to take disciplinary action against the employee. But in any event, that's where those proposed rules stand now. As I say, they were issued in July. Comment period is closed. So now the Department of Labor has to go through the comments and publish a final rule and implement it. All right. In terms of the issue of employees and independent contractors. And I think I've got behind a couple of, sorry about that, a couple of slides here. In terms of misclassification, employees, independent contractors, obviously the whole nature of the work world and workforce is changing. I'm sure you're aware of the case out in California, the Uber driver who was classified. Uber considers its drivers to be independent contractors. A court in California ruled that a driver was an employee. There was an article in the New York Times a couple of weeks ago about the so-called gig economy, where people are basically freelancers, come in and out of the workforce, do a project for one or more employers, come and go. There's no stable relationship. And from a liability and a tax point of view, the classification of an individual as an employee or an independent contractor can have tremendous consequences. From the employer's point of view, for example, if someone is an employee, that individual is entitled to workers' compensation. He or she is entitled to unemployment compensation if he or she gets laid off. They count toward being subject to all sorts of anti-discrimination laws like Title VII, the Age Discrimination Act, the Americans with Disabilities Act, et cetera, et cetera, et cetera. If the employee engages in any misconduct, the employer can potentially be liable for that. If the employee injures a third party or causes any harm or damage, the employer can be liable for that. So it makes a tremendous difference. None of that is true if the person is a true bona fide independent contractor. And from a tax point of view, there are tremendous consequences too, because, for example, you don't pay a lot of employment taxes on an independent contractor. You do share the Social Security, but you're not paying a lot of taxes. So there are tremendous consequences for both the government and the employer, and also the employee, for that matter, the individual, as to what the proper classification is. And this has been going on. The perception that there is an abuse of this system, to be very blunt about it, the perception that employers are abusing this system, that they are simply classifying individuals as independent contractors willy-nilly without any real focus on the true nature of the relationship, that perception has been going on for several years now. And both the Department of Labor and the IRS, as priority shift and focus, etc., and now there's a focus on this from both the Department of Labor point of view and also from the point of view of the IRS. So the Wage and Hour Division is working with the IRS and the states to address this issue of quote-unquote employee misclassification. For example, in fiscal year 2014, the Department of Labor recovered $79 million for workers. The IRS estimates it loses billions of dollars each year, and so the IRS is cracking down. Now, you might ask, two very common situations that I've seen with the nonprofits in terms of the independent contractor are these. One is, let's say an employee retires from the organization or changes location. Let's say you're in D.C. and the employee moves to North Carolina, and both parties want to continue having some sort of working relationship, so they form a quote-unquote consultants agreement. And so the person that was doing a job in one place is now doing it someplace else. That is a prime candidate for misclassification because one of the things that the courts or the Department of Labor or the IRS look at is the nature of the work. And if, as a quote-unquote independent contractor, if you're doing the exact same work and job that you were doing when you were classified as an employee, then that is a signal or indication, whatever you want to call it, a red flag to the IRS or the court that you are still an employee. You may be in a different location, you may be working fewer hours, but if you as a quote-unquote independent contractor are doing the exact same work you were doing when you were a bona fide employee, that is a signal that this is not a true independent contractor relationship. Another signal is if you, the employer, if you, the nonprofit, the contractor, if you're the only client, the only customer that the quote-unquote independent contractor has, that is another indication of an employment relationship. And also, of course, the issue of control. To the extent that you control the means, manner, timing, etc. of the work that the quote-unquote independent contractor does, that is going to be another strong signal of an employment status. So that's one case in which this can arise. If you have a situation in which, as I say, somebody was an employee and then is doing the exact same work. The second one is the one I just alluded to. If you, the employer, you, the independent, you, the organization, you're the only employee, only customer of the so-called independent contractor. One final point, because I think we want to go to discussion and question and answer, is this. How do these cases arise? They can arise from any number of sources. As Ben mentioned before, you might be audited by the IRS, and in the course of that audit, the IRS is going to look at your employment contracts or your relationships with independent contractors. Sometimes it can just be the luck of the draw with the Department of Labor. But two very common ways in which the issue arises are these. Number one, there's a falling out between the independent contractor and his or her employer. And the independent contractor, put it bluntly, out of a sense of vindictiveness or whatever, will go to the Department of Labor and file a complaint and say, I was classified as an independent contractor, I'm really an employee. I was working overtime. I was putting in, 50, 60 hours a week, and I was only getting a flat retainer of, whatever it is, $1,000 a month or something, and I was really an employee. So there's a falling out and there's a complaint. Or a second issue, a second way in which these cases can arise is if the relationship is ended. So you say to the contractor, we don't need your services anymore, and that individual attempts to apply for unemployment benefits. Then he or she will file a claim with the state unemployment office and say, I was an employee, because, of course, independent contractors, true bona fide independent contractors, are not entitled to unemployment compensation. So the individual will go to the unemployment office and say, I was really an employee. And then that becomes an issue in determining whether or not the individual is eligible for unemployment benefits. So with that, I'll stop, and Mac, we can go on to the panel discussion or questions, whatever comes next.
Okay, well, thank you. Well, I'll just stick with you, Jerry.
All right.
As we begin our panel discussion. You talked about exempt versus non-exempt, employee versus contractor. What happens if I, as an employer, have determined through, I don't know, somebody raising a red flag or something, that I've classified somebody incorrectly? What do I do next?
If you've incorrectly classified somebody as exempt who should be non-exempt?
Right.
All right. Basically, what you need to do is this, and I'm the first to admit this is not an ideal or perfect solution, but for reasons I'll explain, it's about the best you can do. Basically, what you need to do is this. You need to determine how many hours that individual worked, how many overtime hours. And there may be, you may have records. Some organizations require employees to keep track of their time, whether they're exempt or non-exempt. The employee himself or herself may keep track of his or her hours. So the first thing to determine is, number one, has this employee worked any overtime hours? That I've now come to the conclusion I've misclassified as exempt. Has the person worked any overtime hours? Number two, what are those hours? Now, number three, how far back do you go? You go back, if it's a non-willful violation, you go back 2 years. If it's willful, you go back 3. The safest, most conservative advice, obviously, is to go back three years, because it doesn't take much to prove willfulness. If you don't have any records at all, you make your best guess, to put it bluntly, as to what the individual is owed in terms of overtime compensation. Once you do that, you go to the employee with that. You say, we've made this determination according to our records. If you have any records, and this is a negotiation, you go to the employee and you say, according to our records, you've got, let's say over the last 3 years, you've got 100 hours of overtime at X dollars an hour. We conclude that we owe you an additional $2,000 in compensation. And then you enter into an agreement between you and the employee that this is the amount that the employee is earned. Now, the next step that arguably the Fair Labor Standards Act requires you to take, but I can understand why the organization would be reluctant to do it. Under the Fair Labor Standards Act, you cannot have what are called, quote-unquote, unsupervised waivers or settlements of Fair Labor Standards Act claims. So if it's just you and the employee negotiating a private deal, a private agreement, just between the two of you, which has not been approved by either the Wage and Hour Division or a court, technically speaking, the employee can still challenge that agreement. So ideally, if you wanted to go the last mile, the last 6 inches or something, once you came to a resolution with the employee, you would present that to the Department of Labor, the Wage and Hour Administration, for approval. Now, nonprofits are reluctant, obviously to do that because they don't want to call attention to themselves. They don't want to trigger a Department of Labor audit. So I can understand that, and so you can stop at a settlement or agreement between you and the employee, but just be aware that at some point in the future that could be challenged. That could be challenged because it was not approved by the Department of Labor. But that's essentially the way you do it. You find out, you make your best determination, do we owe this person any overtime or not? And if so, we pay it, and you get a written agreement with the employee. Obviously, there's some negotiation here. I accept this as payment in full of what I'm owed, and for what it's worth, I release the employer from any further claims, and hope that it resolves the matter. But that's the best you can do.
Okay. Well, I guess if that's the best you can do, that's the best you can do. Ben, I had one question come in that was along the lines of what I was going to ask you anyhow, but maybe you can expand on it for us. So we have the Form 990. There's some changes that hopefully will be made as more digitized format, which I guess it makes it easier for organizations to file, but it also seems like it's going to make it easier for organizations to search them. So it's our understanding that some states will review these as you typically do to check the charitable status of nonprofits. Do we know if some states might be stronger to do this than others, or are there any trends?
Yeah, good question.
Something like that. So.
Yeah, well, there are a couple considerations in this question. First of all, as it stands now, is my experience that state governments use whatever is at their disposal to enforce the state charitable solicitation laws and their own tax law. So they use a variety of methods, and an example that I dealt with, just to illustrate this, I had a nonprofit client who holds an annual conference every year, as many nonprofits do, and just like other nonprofits, they like to move their conference around to different states every year. And they happened to be doing their conference in Nebraska a couple of years ago, never registered in Nebraska, never secured tax exemption in the state. They were a nonprofit based in D.C., very little activity in Nebraska outside of this one conference. And lo and behold, Nebraska found out about the conference and then came in with a whole bunch of issues. Charitable solicitation was one, and also tax liability for all the conference revenue that they brought in. And, we don't know exactly how they found out about this, but they do check websites, and there's plenty of public information that alerts state authorities to what nonprofits are doing in their state and throughout the country. So that's one thing to keep in mind. They are on the lookout, and they will use whatever methods they can. The 990s are public documents, so this is another tool at their disposal. You can get these through GuideStar. You can request them from the IRS. You can request them directly from the organization. And there are laws requiring you to provide these documents. So they can do a lot just with the publicly available information. Now, once you do register under the charitable solicitation laws, about 40 states have these laws regarding registration being required before you can solicit contributions. And I don't know the exact count, but I think pretty much all of them require some financial information and or some version of the Form 990 as part of that registration. So keep in mind that is a big part of how they get their information. Now, the issue that I talked about specifically was regarding the donor lists and the donor identities, because normally that is redacted from the publicly available Form 990. But as I mentioned, 3 states in particular are being very aggressive about this: California, New York, and Florida. They're insisting that you provide the full donor list, unredacted. So those are the states you need to be most careful about, and they also happen to be the most aggressive when it comes to regulating nonprofits.
Okay, great. And a couple of our attendees couldn't hear the question that was being discussed, and we were talking about the Form 990 and what states might use the information in that to check on charitable statuses and stuff like that. Mm-hmm. So we've reached the Q&A portion of our webinar. So if you have any questions, please feel free to log them into the dialog box on the left-hand side of your screen, and we'll try to get to as many as possible. If one come in, can we clarify the proposed regulations for employees earning less than $100,000? Are they automatically considered non-exempt, or can other issues, management responsibilities, still be considered? Jerry, I think that one's targeted towards you.
Sure. Do I need to repeat that?
Yes, go ahead and repeat it for me.
Okay. All right. The question is, in terms of employees earning less than $100,000 a year, what is their status? Will they be considered to be exempt or non-exempt? The answer is this. There are 2 separate classifications. Okay, the first classification for exemption is that you're right now, under current regulations, you're earning a salary of at least $455 a week. So as long as the individual, and again, there are 2 tests. Number 1, as long as the individual is earning at least $455 a week in salary, and number 2, depending on what type of work the individual is doing, if it's exempt work, if it's creative work, if it's managerial work, if it pertains to a line of business like being the CFO or a financial person or an accountant or a creative director. Or also there's an exemption for computer people. But as long as the person is making $455 a week, is earning $455 a week in salary, and is doing work of an exempt nature, that individual will meet the test for being classified as an exempt employee, even though he or she is earning less than $100,000 a year. In fact, as I pointed out before in my main presentation, if you take $455 a week and multiply it by 52 weeks, it comes out to something like less than $24,000. So as long as the individual is getting a salary of at least $24,000 a year and doing exempt type work, he or she can still be classified as an exempt employee, even though the person is not earning $100,000 a year.
Okay. On the exempt rules, Jerry, Ben, any idea when those might become law? What's the time frame going forward on them?
Well, if I may, okay, in terms of the proposed regulations, when might they become final, or what's the next step? I think I don't know about. I'd be interested to see what Ben says, but from my answer to that is I think anybody knows. I mean, it's anybody's guess, because number 1, I think it depends on how many comments they get, and for something this major, I mean, these, as I say, these are huge adjustments in these tests. I mean, you're going from $24,000 a year to $50,000 a year, automatic adjustments every year. I'm sure there are going to be many, many comments, hundreds, maybe a couple thousand, and you know, they're going to weigh in. So it depends on how long it's going to take the Department of Labor to sift through all the comments. Then, of course, the Department of Labor has to write the final rule. And then, as I said before, depending on the political situation, I suppose the possibility exists that any final rules will be rescinded in a new administration. So I would say, this is just a wild guess, but I would say it's going to be at least a year before you see any final rule.
Yeah, especially. Well, I was just going to add, there's so much money and resources at stake with this decision. So, and a lot of very big industries are going to be affected. So, I would guess this is one of those issues that's going to take a while and going to be very contentious.
Yeah.
Okay. Did you want to go on? Do you have something else?
No.
Okay. All right. So now we've got the exempt versus non-exempt going pretty well in the Q&A block. How about we jump towards the independent contractor label? Is there a checklist, guys? Factors that we can follow? You know, I know we indicated earlier that, you know, we can make some mistakes and some of the law might be a little fudgeable, but is there best practices that we can give our listeners?
Ben, do you want me to start, or do you want to start?
Well, I jump in and you can take it from there, but I will say there is, from the IRS perspective, at least regarding tax withholding and the tax issues that are triggered by the employee versus independent contractor determination, the IRS has a 20-factor test. I believe the guidance is an old revenue ruling 87-41, I believe is the right number. And they go through 20 different tests, similar to what Jerry discussed about the degree of independence of the worker, whether there are instructions, what amount of training, how many clients does the worker have besides the one that they're reporting to. So those are the kind of factors. But like Jerry discussed, it's very facts and circumstances kind of test. So it's very hard to have certainty. But there are checklists, and the IRS has a 20-factor test that you can use to at least help you. Jerry, what would you add?
Well, a couple things on the IRS test. Well, first of all, there are a number of tests. There are, depending on what the situation is, there are 4, 5, or 6 different tests. The IRS test is just one. Then there's the so-called economic realities test, and there's also the so-called hybrid test. And I'll briefly comment on each one. With respect to the IRS test, as Ben said, it's 20 questions, but they have subdivisions. So I think if you count the subdivisions, it's more like 60 questions than 20. But there's that factor. But that's just one test. But here's the maddening part about it, quite honestly. Yes, there are checklists to answer the question asked. Are there any checklists? Yes, there are. The problem is checklists vary from court to court and circumstance to circumstance. And number 2, the courts will say that no single factor is determinative. It's a case-by-case individual assessment. So there's not a checklist in the sense that it's 1, 2, 3, 4, 5, 6. It's black and white. You just check them off. Yes, no, yes, no, yes, no, yes, no. Answer comes out, independent contractor, employee. And to give you an example, under the economic realities test, the basic issue there, 2 basic issues. Number 1, who has the right to control and direct the work of the contractor? To the extent the employer controls what the contractor does, when, where, how, number of hours, etc., that is going to be a sure sign that it's really an employment relationship. The second big factor there. So this is of a checklist of let's say a dozen items. These 2 are going to have much more weight than the other 10. The second factor is this: is the contractor's risk and opportunity for profit or loss independent of the employers? So, for example, let's say Ben or I have our own businesses, all right? And if you're a client of ours, you may be doing great, we may be doing poorly. We may be doing great, you may be doing poorly. Our opportunity for profit or loss is completely and totally independent of yours. But where you have a situation, and I mentioned this before, where let's say you, the organization, you're the only client or customer of the so-called independent contractor, then if that person loses your business, he or she has lost everything. So there is no independent risk of profit or loss. That's going to be, again, a very strong indicator of an employment relationship. And then finally, as I said, the test is going to depend on the circumstances. You're going to look at the IRS test for purpose, let's say, for tax purposes, for purposes of determining employment under Title VII, the anti-discrimination law, or for purposes of determining coverage under a workers' comp statute, or for purposes of determining eligibility for unemployment compensation. Those agencies, EEOC, Unemployment Compensation Board, Workers' Compensation Board, they're going to apply their own tests, which are going to be a combination. That's why they call it a hybrid. A combination and mishmash of the IRS questions, common law tests, and the tests that they've developed in their own particular fields of expertise. So, yes, there's a checklist, but there are many checklists, and none of them are definitive.
Jerry, I'd like to get your thoughts on one issue in particular. I know the IRS has a procedure whereby you can put some of these factors in writing and get their determination and view on the appropriate classification. Is that something that you would ever recommend a client do, or do they need to reach their own conclusion and get comfortable with that?
Ben, you know what? As a general proposition, and I may be in the minority on this, but as a general proposition, I would recommend that for the simple reason. First of all, I think the fear that by exposing yourself to the IRS, you're going to trigger all sorts of problems and audits and difficulties and everything else. I think that may be overstated, as I think you may have implied in your presentation. I think the IRS is busy enough with everything else it's got to do, without something like this. But secondly, and more importantly, that gives you an authoritative, definitive answer. I would be the first person to admit that a client could pay me for any amount of money for any amount of time to research every case and opinion back to 1938, for example, on the proper classification of employee, and I could do the best possible job imaginable, but that is still not going to be definitive. The IRS or a court or somebody else could come in there and say, we don't agree, this person is not exempt or not an independent contractor. When you go to the agency, like the IRS, that answer is authoritative and definitive. So my answer to that question would be, I think in certain cases it may be worth doing, yes.
Well, we did have the Affordable Care Act pop up in the Q&A window. We knew it was going to happen, so we might as well just address it. But it's specifically about temporary employees. I'll just read the question straight here. Any thoughts around the ACA liability for a nonprofit when they hire a temp employee through an agency, despite the temp being on the agency payroll, as opposed to the nonprofit's payroll? The questioner has read that some things about the nonprofit possibly having some responsibility to provide ACA-compliant health care coverage, as opposed to the temp agency. Do you guys want to wade into that one?
Mac, I have to admit, I just do not know the answer to that. I recall seeing something along those lines about who the employee belongs to with the temporary agency, but I just don't know enough about it. I wouldn't want to venture an opinion. I'm sorry.
Yeah, me neither. Affordable Care Act is kind of becoming its own niche and specialty, so not something I have a lot of expertise in.
Well, I appreciate everybody's honesty. That way we won't leave this right here. Okay. What steps do you need to take if you find you have a contractor that should be an employee? We've already covered that a little bit. But more specifically, when you bring them on board, negotiating that salary, any ideas when you're bringing that person on board to negotiate a salary, Any advice on that type of action?
Okay, so any advice on when you're bringing an independent contractor on board, when you're negotiating the terms of the agreement? Any advice on negotiating the salary? Okay, first of all, I would definitely not call it a salary. You want to call it an hourly rate, or you want to call it a retainer, or anything, but you don't call it a salary. That's a sure giveaway with respect to employee status versus independent contractor status. And then secondly, for what it's worth, I would put in the boilerplate language that the contractor has no interest in directing the means or manner of contractor's performance, but is only interested in final results and general objectives. And it is the intent of the parties to create a contractor-independent contractor relationship. But I would, however you categorize the pay, I would put it in terms of a retainer or an hourly rate. You know, I will perform work for you at the rate of $1,000 a month, or at the rate of $200 an hour, whatever it is. And another factor too, and again I keep saying what it's worth because you know it's, as I say, it's case by case. But another factor too is that you be able to terminate the relationship almost at will. You put a clause in there that says, for example, the contractor can terminate this relationship upon 30 days' notice to the contractor. The employer can terminate on 30 days' notice. You don't have severance pay in there because that's a mark of an employment relationship. If you want to have kind of a backdoor type of severance agreement, you know, you may say that this agreement may be terminated upon 3 months' notice. But I wouldn't make that too long. But you have to be able to terminate the agreement fairly quickly. So those are some of the criteria that I would look at. Oh, and here's another question that comes up with these independent contract arrangements, and it's got two sides to it. Some clients want to have a non-compete clause in the independent contractor agreement. On the one hand, that is a sure sign of an employment relationship. That is going to that's going to be a red flag. But on the other hand, there's no question it's a legitimate interest. You know, take example people like Ben or me. We have to be very careful about not getting involved in a conflict of interest situation between clients. And if we represent one client, or you know, we may be precluded from taking on a representation of another. So that is perfectly legitimate. So you want to be very careful as to whether you have such clauses. Think about whether you really need it or not. And if you do, you may want to characterize it more as avoiding a conflict of interest than a non-compete clause. So those are some of the pointers I would give, generally speaking, when you're negotiating the independent contractor relationship.
Okay, well, it looks like we have time for one more question. See who the winner is here on this question. Do you guys see one in there that you feel like you want to answer, or you want me to just pick?
The one about the 1023 easy. That looks like it's Ben's question.
Yeah, that's a one I can answer pretty quickly. The 1023 easy, as I mentioned, is this new streamlined way of getting 501c3 status. You have to be a small organization projecting less than $50,000 a year for the first 3 years. So the question is, what happens if you exceed those projections? Now, that will not invalidate your 501c3 status or your application, provided that the projections were reasonable at the time you made them. The IRS, if it was determined to be fraudulent, they could retroactively revoke your status. But if this was a good faith, reasonable projection, nothing bad is going to happen to your C3 status because you go over. You just may be at the risk of getting an audit because the IRS will be looking to see that you're small. So if you end up being a big organization, that could trigger the IRS to come in and take a closer look.
Excellent, excellent. Well, guys, we're out of time, and I thank you all for spending the hour with us. We do have some questions left in our queue. I'm going to forward those to the appropriate legal scholar, and as their time allows, we'll ask them to respond to you all directly. Our next webcast is January 25th. It's going to be on executive compensation strategies for nonprofits. It'll also be worth an hour worth of general HRCI credit. For those of you who need the HRCI credit for today's webinar, that email will come to you later this afternoon with the proper information about how to get that credit. So just keep an eye on your inbox, and if you don't get an email, which you probably should, you can please feel free to email me back, msmith@501c.com, and I will be happy to get that information to you. But on behalf of everybody on the call, thank you all for attending, and we look forward to everybody having a great holiday season, and looking forward to seeing everybody again in January. Have a great day. Bye-bye.
Thanks, Matt. Take care. Bye.
Thanks. Bye.